Today on Uncommon Knowledge, having your tort and eating it too.
Funding for this program is provided by the John M. OLIN Foundation.
Welcome to Uncommon Knowledge. I'm Peter Robinson. Our show today, tort reform. During the last presidential campaign, one of the principal planks of President Bush's domestic platform was tort reform. Tort is simply a word that means harm, and when the lady sued McDonald's for serving her coffee that was too hot and collected a huge amount, the law under which she did so was tort law. President Bush believes that tort law as it now stands permits trial lawyers to take advantage of good companies, driving up the costs of doing business for everyone. Others believe that tort law, as it now stands, permits consumers to protect themselves against bad companies. Which is it? And should President Bush be given the tort reforms that he wants? Joining us today, two guests. David Davenport is a professor of law at Pepperdine University and a fellow at the Hoover Institution. Alan Morrison is a senior lecturer in law at Stanford Law School and a co-founder with Ralph Nader of the Public Citizen Litigation Group. Journalist Eamon Javers, quote, "There are those who say people are taking advantage of good companies with lawsuits, and others who say suits with million-dollar penalties are the last best hope for people to get companies to stop taking advantage of consumers," close quote. Tort law in the United States as it now stands. Consumers taking advantage of companies or companies taking advantage of us. David?
The balance has shifted toward consumers taking advantage of companies.
Alan?
The other way around.
Other way around. Well, that's as simple a disagreement as we could ask for. Now, let me ask two men well versed in the law to give me a layman's education in this matter. What's a tort?
A tort is a wrong that someone commits to another. It's usually some kind of harm or some kind of injury that is caused either by a person or a product.
Why do we use such a strange word as tort?
The word tort is a French word for wrong.
Right.
And so David and I at least agree on something.
Exactly. Now, do we know roughly what proportion of tort cases are tried in state courts as opposed to federal courts?
Very heavily in state courts.
Very heavily in state courts. All right, now,
that's because in general our tort law is state-based law, and all the proposals to change that law that are being debated now are federal government would change state law.
You are anticipating me slightly here. So if we're talking about a branch of law that arose centuries ago in English common law and under which most cases today are tried in state courts, David Davenport, I ask you what makes the President of the United States think he has any right to intervene or that he can fix anything?
Well, the federal government reserves power over state courts in a couple of ways. Under Article 2 of the Constitution, Congress has a fair amount to say about court jurisdiction. And under the Commerce Clause, the federal government has opportunities to take action when they feel things affect interstate commerce.
Okay. The President wants tort reform in three areas: class action lawsuits, asbestos liability, and medical malpractice. Now let's take each of these in turn, and I promise you'll get a chance to make your larger points as we discuss each of these. He has one of the three. Passage in February of the Class Action Fairness Act of 2005. Now let me ask you, for the brief layman's education, what's a class action, and what did the Class Action Fairness Act of 2005 do about it?
A class action is a device by which a large number of individuals, typically with very small claims, and by the way, almost none of them are tort claims in the kind that David and I have been speaking about. These are mostly consumer fraud cases. Tort cases typically involve personal injury cases.
So we call it tort reform. We're speaking in a
the President likes to use that term.
Loose sense.
Loose sense, yes.
All right.
He calls it lawsuit abuse, and so it comes in the back door. But basically, a class action is a device that enables a large number of individuals to join together in a lawsuit that would be economically impossible to bring as individual cases because the amounts at stake for consumers, perhaps $50, $100, $200,
okay,
against a large corporation, nobody could afford to have a lawyer, and no lawyer would take the case unless you could aggregate all the claims together.
And the act of the 2005 Class Action Fairness Act does what?
It basically takes all of those cases that were brought in state court. These are state law cases. Federal law cases, for example, under the Federal Securities Act are already in federal courts. These are state law cases that have always been tried in state court, and they move them wholesale into the federal courts.
Okay. Does a conservative like David Davenport really want the federal government taking all these cases out of state courts? Plaintiff's lawyer Al Meyerhoff, quote, "The Class Action Fairness Act will federalize most class actions, just as Alan explained, taking them away from local courts and juries, already overburdened. Federal courts will be required to resolve complex issues of state law, while many victims may kiss justice goodbye," close quote. In other words, what you have here is a massive usurpation by the federal government of powers that belong to the states and an overburdening of the federal judiciary system with cases it is ill-equipped to address.
Well, that's assuming lawyers don't change their strategy. I would assume that now many of these will be brought as individual cases in state courts. Still, class actions can be brought state by state, so a lawyer can file multiple class actions in multiple states. But of course, part of the strategy is that there would be a reduction of some of these cases, which are viewed to be in many cases frivolous and excessive.
I see. Okay, so you get around the problem of overburdening the federal judiciary by saying, no. Now that we've changed the law, trial lawyers aren't going to be bringing cases like this.
We're going to have far fewer of these cases.
Okay.
It's the point of the law.
Right. And you'd agree with that?
Oh, certainly is. It's the point of the law.
Okay.
It's unabashedly the point of the law. The defense bar believes that it will win more cases by having these cases heard in the federal courts. They make no bones about it. I want to be clear that there are some of these class actions, nationwide ones in particular, or cases that are filed, overlapping cases in multiple state courts, which perhaps should be brought into the federal courts.
Right.
And I've supported, and others have supported, a much more limited bill that would do that. What's wrong with this bill, I mean, aside from some other technical things, is it essentially reverses everything, and all of these cases, with very few exceptions, and I'm not even sure that even the local state-based class actions can stay in the state court, they're all going to be in the federal court. And the federal judiciary is not very happy about this. Obviously, they have to stay out.
Alan, here's the reason. I'm quoting the Wall Street Journal. The trial bar has perfected the legal art of forum shopping. That is to say, they go from here to they end up, apparently there's a county in Wisconsin, I believe, one county which is especially notorious as a good place to, Illinois?
Madison County.
Madison County, Illinois, exactly. One county in Illinois where from around the country, they try to file as many class actions there as they can. I'm continuing the Wall Street Journal, these mass tort claims have become a source of legalized extortion that rewards lawyers with cash, but plaintiffs with coupons and pennies. And incidentally, I read that and thought, yeah, oh, so that's what that coupon was all about when I got $5 from some airline or something like that, a coupon.
Precisely.
Okay, so the notion here is that this is just out of control and that something had to be done.
Yes, perhaps something had to be done, but whether they had to go as far as they went here is a completely different question. And it's obvious that they weren't talking about just the Madison counties of the world, because you could have written, as I drafted, a much narrower bill, and they weren't interested in that. They wanted the home run, and that's what they got.
Was the bill overbroad? If you had your druthers, would you have gotten in there and drafted it slightly differently?
Well, no, because I still think that creative lawyers will bring these class actions in
Oh, you're a hardline
courts.
man. This bill was just what was needed.
Well, I think it's up to the federal government to decide these procedural matters, and I think it's good that they did, yes.
All right. Next, tackling the asbestos mess. Asbestos, substance widely used for insulation for much of the 20th century. Turns out that it causes the lung ailment asbestosis and a terrible form of cancer, mesothelioma. In over 30 years of litigation, what happens first is that the major manufacturers of asbestos are sued, Johns Manville, Ray Bestos, a couple of others. They go bankrupt. So suits begin to be filed against construction companies, steel makers, virtually any company, any corporation that used asbestos ever for any purpose whatsoever. Professor of law Lester Brickman, journalist Harvey Shapiro, quote, "There is little doubt that after 30 years of lawsuits, the biggest beneficiary of the asbestos mess has been the plaintiff's bar to the tune of $20 billion in fees so far and counting. Just as asbestos has been removed from buildings around the country, the bulk of asbestos litigation should be removed from the legal system, close quote. Of course, they're correct, are they not?
It's time for the asbestos litigation to largely get out of the court system. The problem is finding a way to do it without substantively injuring the victims and without creating a mess that was even worse than we have now. One of the major problems is that everybody agrees that there ought to be, well, not everybody, a large number of people agree there ought to be a fund created. The problem
You agree with that?
I think now it's time for a fund to be created. The problem is who is going to pay what into the fund. We have fights between the insurers, the reinsurers, the companies, the various levels of companies involved. What do you do about the bankruptcies? And then the question is, who gets paid what out of the system? And there has been an inability to reach any kind of agreement on these big dollar and cents issues. So talking about an alternative system is fine, but you have to get to the details, and that's where it's broken down so far.
So the proposal that gets surfaced in the press over and over again, Republicans in Congress want to, but as far as I can tell, the administration has not embraced this. They smile upon it, but this is not the president's proposal yet. Republicans in Congress want to establish a $140 billion industry-backed fund to settle all the claims in exchange for ending all litigation. But Alan makes a very good point, does he not? How is it that Congress can legislate the kind of extremely detailed negotiated settlement that this would certainly entail?
Well, I think there are hard questions of federalism here, but the particular one you've asked I don't think is so hard.
Really?
I think a legislature is in far better position to state and negotiate details than 50 state courts, which is kind of what we have now. And so I think Congress is in good position to work out the details. I think there are 2 or 3 hard questions. How much money should go in? 140 billion, some think is high, some think is not enough. Secondly, I agree with Alan, a hard question as to what does insurance pay in, what do companies pay in. The third hard question, which is what I struggle with, is they still aren't doing much in the bills that I've seen to change the standards for recovery. I think the standards for recovering in these cases have been much too loose, and I think under federal legislation they may still be.
So what you're saying is that there are hard questions involved, but even at that, what Congress is considering doing is striking a deal, not really reforming tort law, the underlying.
I think in the case of asbestos, that's a fair assessment.
I think everybody understands that. That's what's going to have to be done if they're going to be able to do anything.
On to the third target of tort reform, medical malpractice liability. President George W. Bush, quote, "What's happening all across this country is that lawyers are filing baseless suits against hospitals and doctors. They know the medical liability is tilted in their favor," close quote. Is medical liability tilted in favor of plaintiffs' lawyers?
Well, in some jurisdictions it is. Some states have stepped in and made changes to prevent it. But in some jurisdictions it is, and that's caused malpractice insurance to go sky high and has had many, many implications on the healthcare system, including it's one major reason you're paying a lot more for health insurance.
Several answers to that. First, the data I've seen, and admittedly they're not real good data in the sense of being scientifically validated, about 50% of the cases that go to trial at least are won by the doctors. So, at least. Okay. The second thing is many of the worst cases against the doctors are settled before they go to trial. Third, the notion that everybody is ripping off the system completely forgets about the fact that many people are being very seriously injured. If a person loses a leg, or a woman loses her right to reproduce, or a child is born with birth defects and is going to be essentially unable to do anything the rest of their lives, the notion that they should be not fairly compensated is quite unfathomable to me. But that's what this bill that the President is supporting would do. 2004
Medical Malpractice Reform Act, which fails, but it seems reasonable to suppose that the administration will introduce something like it.
They have.
Oh, they have. All right. Centerpiece of that act is capping non-economic damages at $250,000. Actual damages and medical costs remain uncapped, but damages for what in popular culture the pain and suffering is capped at $250,000. Why does it make sense to remove from juries the ability to make the payment fit the suffering?
Well, because juries have a bad track record at doing that. Jury verdicts are all over the map. Similar injuries can receive widely differing amounts of compensation. And so a cap is one way to deal with that in terms of reform. Another might be to take that away from the jury, and once they've decided that there are punitive damages to be involved, for example, the judge assigns that. You could also say that the non-economic damages can't be more than 2 times the actual medical damages. So there's several ways to reform that.
Are you pleased with a cap?
To be honest with you, I think the cap is sort of a crude tool, and I'll again be honest and make a little gesture toward my colleague.
Not too much honesty, it's bad for television.
I'm not sure $250,000 is high enough for some of the cases. I agree there's some very bad cases. What I want to do is to weed out the frivolous and non-meritorious cases so that the people who are truly injured can get an appropriate recovery. And $250,000 may not be enough.
How do you weed out the frivolous? Oh, you just adjust the number? That's all you're interested in doing? Or?
I would like to put caps on punitive damages, but I would make them a multiple of the actual damages that are suffered, as opposed to putting a $250,000 cap or something.
Oh, I see.
Secondly,
so you fix that actual damages.
Actually, the bill that's introduced
is non-economic.
It says punitive damages are twice the actual damages. I should just say or $250,000, whichever is greater. The cap on it.
Why is $250 a bad idea?
Well, first place is it penalizes mostly women, because by and large women have fewer economic damages because they work less.
Right.
They stay home and take care of their children.
Damages usually.
The second is, in many medical malpractice cases, women's reproductive systems are what is being malpracticed. And the result is that when you're told that you can't have a child, the most you can ever get is $250,000 for non-economic damages. The same with a child. A child who was injured has no earnings, and hence no earnings history, and hence can't prove economic loss in the future. The only thing that child will have, losing a leg or being brain dead, is $250,000 plus the medical expenses.
Okay. So how would our guests reform medical liability? We agree that medical liability needs to be addressed. We agree that the current... Oh, you'd leave it alone?
I don't think...
So if I say to you, medical liability reform according to Morrison, you'd say, leave it as it is.
No, I have 2 things, but they're not this kind of reform. The first thing I would do is I would start getting bad doctors out of the business. There is almost no doctor discipline for doctors. Second thing that happens is that doctors do not pay increased malpractice insurance when they commit malpractice. 5% of the doctors commit 50% of the malpractice.
And there's no way for insurers to punish them.
No, the insurers choose not to raise their rates. If you and I get in a car accident, we raise our rates. Insurers don't do that. It seems to me, if you're going to talk about tort reform and trying to help the victims, you would be thinking about doing something different from what they're doing here.
David?
I would do the class action reform and the asbestos reform at the federal level.
Just about as the president has done it.
Just about as the president has done it.
Wants to do it.
Although I might do even more. I might also say at the federal level that unless a business is actively set up and doing business in a state, that you can't bring an action in that state. Now, what I would do at a state level is I would do the actual tort law reform, including the medical malpractice reform, at the state level. Because I agree with Alan, tort law is essentially state law. It's not largely federal. And I think there would be a variety of tools that states might experiment with so we could get some data and experience.
Now you're making the federalist argument.
Well,
now you're saying that we really do need these 50 states around as laboratories to experiment with
yes, I agree with that. I believe it's the federal government's role to deal with the procedural questions, which I think includes class action. I think occasionally you'll get an asbestos-like case where the federal ship has run aground and we're going to have another solution. But other than that, I would do the malpractice reforms and the other kinds of reforms at the state level, and let's see what works.
And you get a kind of torquing of the political system whereby a state that does enact an effective tort reform becomes friendlier to a business climate.
Precisely.
And so neighboring states...
Instead of paying money in Mississippi for tort damages, they'll go pay taxes in a state that has more appropriate laws.
So in some way you ought to be able to rely on the political system of the 50 states to respond to this problem.
Right.
All that makes sense to you?
He is surely right. that the states are the places to do this. The business community has lots of power in the states. The doctors have lots of power in the states. There are experiments going on. Some of them are sensible. Some of them are very bad. For example, here in California, the tobacco lobby persuaded the legislature to make it impossible to sue on cigarette smoking for a period of about 10 years. Suddenly, the legislature woke up and said, wait a second, that's a terrible idea, and they changed it. If we do this kind of change at the federal level, it will be centuries before we'll be able to do anything about it, because it's national.
Finally, the politics of tort reform. Who wants tort reform? Industry, doctors, insurance companies, all important supporters of the Republican Party. Who gets hurt? Trial lawyers, a key constituency of the Democratic Party. So, David, what's going on is not genuine legal reform, it's politics. At this moment, the GOP is triumphant, and it is moving against its political enemies.
Well, I believe in the burning platform theory of change, which is until the platform is on fire, you're not going to jump off. And so I think it's because business and other constituencies see the platform is on fire. We're spending as much as $250 billion a year, 2 to 3% of gross domestic product, on tort and related product and service insurance. And so the platform's on fire. That's when we jump.
The political component of this doesn't bother you at all. That's just the way politics works.
Well, I think that's part of the system, is pressure is brought to bear when change is needed.
All right. David Bernstein, law professor at George Mason University, Allen. Ordinary Americans will, quote, care that they're ordinary Americans, not industry, care that their local doctor is more likely to stay in his or her practice if tort reform takes place, or that when they go to Home Depot, the ladders will cost 20% less because people aren't falling off them and suing for millions. Scaling back the tort system probably won't have any effect on the ordinary American's health or safety, but it probably will save him some money. So tort reform represents a large transfer of wealth from the tiny coterie of super-rich trial lawyers to the vast numbers of ordinary Americans. And not for that reason alone, we ought to embrace it.
One of the features of the Bush tort reform proposal is to put caps on the amount of fees that lawyers can be paid in tort cases. Aside from the affront to federalism, the notion that the federal government is now going to be controlling state law, they're now going to be regulating, in effect, regulating what lawyers can do.
Right.
Leaving aside those things, the claim is, of course, that if we lower contingent fees, that the victims will get more money. But 100% of nothing is still nothing. And if the contingent fee is so low, as it is in many of these cases, and the cases are extremely difficult to try, complicated, lots of expert witnesses required, the answer is going to be very simple, which is largely the answer here in California now. Nobody is bringing medical malpractice cases unless they're very, very seriously injured and very large economic damages. Now, that...
Yeah, but you know what? Since 1970, malpractice premiums in the state of California have risen only a third as high as in most of the rest of the country. We should rejoice.
Tort reform.
We should rejoice. And why? Because in 1970, California capped non-economic damages.
Well, it hasn't been reflected.
Because hard cases make bad law, right?
Maybe. It also is not reflected in our health insurance premiums, which have continued to skyrocket. The transfer is occurring from the people who are injured and who have to pay for these injuries themselves or just simply suffer in silence. Those are the people who are being injured. These are not people who are not injured. They may not have any legal claims, although in many cases they do. But the question is, what's happening to them?
Just a final question to you before we close out the show here, David. You may argue until you're blue in the face that the large proportion of these cases are frivolous, and then every so often you come across somebody who doesn't get enough oxygen at birth and is brain damaged for I mean, you do come across these cases which are heart-rending. How do you do?
To
how
me,
do you
to me, the part of tort reform is to carve out as much of these frivolous cases as possible and take them off the table so that there will be adequate money to compensate the people who are correctly injured. As you've pointed out, in our present system, with all of the money we spend on torts, both on the insurance side and on the legal side, over half of that ends up either in lawyers' hands or in administrative costs. It's not going to the victims. So tort reform, I think, creates new possibilities for seriously injured people.
Last couple of questions here. As we noted at the top of the show, President Bush wants 3 kinds of tort reform, and he got 1 in February with the passage of the Class Action Fairness Act of 2005 rather. Before George W. Bush leaves office, is he also going to be able to sign into law asbestos liability reform, which he wants, and medical malpractice reform, which the two of you say he shouldn't want, but he wants nevertheless? Is he going to get asbestos reform?
I think that's almost a coin toss. I would say he will get it, but the forces have gone back and forth so often that I'm not confident.
Alan?
Very difficult to say because the principal combatants in this are the industry, the various parts of the industry and the insurance industry, and they have to reach agreement on a division of the payment, and the money makes it very hard to imagine it's going to happen, but it might.
Medical malpractice reform, is he going to get a federal
I think he
malpractice
probably
reform?
is going to get a bill, though, as you heard me say earlier, I would prefer to let the states work on this one.
I think he will not get a bill. I think the people will realize that independent studies have shown that 90% of the malpractice activities at doctors and hospitals never are the basis of a lawsuit. The leading cause of malpractice litigation is malpractice, and that's not going to change.
Alan Morrison, David Davenport, thank you very much.
Thank you, Peter.
I'm Peter Robinson for Uncommon Knowledge. Thanks for joining us. We welcome your comments on this week's show. Our email address, comments@uncommonknowledge.tv. For more information about Uncommon Knowledge, please visit our website, www.uncommonknowledge.tv.
Funding for this program was provided by the John M. Olin Foundation.